This is the CitizenLink Report.
If you find our insights helpful, would you support our video efforts? Your gift of $25 or more goes a long ways. Covers the crew, lights, cameras, all that. Just click on Donate. Thanks from all of us.
Proposition 8 will go before the California Supreme Court. That makes the 5th time in 9 years the state Supreme Court has been asked about same-sex marriage. This is the CitizenLink Report. Hi, everyone. I'm Kim Troby, and I'm joined by Bruce Hausknecht. He's our legal analyst here at CitizenLink. Hey, Bruce.
Hi, Kim.
Okay, there's a lot of confusion surrounding recent Supreme Court rulings on this issue. Let's start there.
Well, in the last couple of days of June, the Supreme Court handed down the 2 marriage decisions. One of them had to do with the federal DOMA, the Defense of Marriage Act. The other one had to do with California's marriage amendment, also called Prop 8. Now, the Prop 8 case was essentially not decided. It was kicked back to California. The Supreme Court decided that on a technical issue, the proponents of Prop 8, the people who brought it to the ballot and got it passed, were not the proper parties to appeal the loss or the declaration that it was unconstitutional at the trial court in San Francisco. So it started in San Francisco, went up to the Supreme Court. They decided that no one had the right to appeal it, and they sent it back down. And on the way back down, they also tossed out the Ninth Circuit decision that also rendered it unconstitutional. So all we're left with is a federal district court judge in San Francisco, Vaughn Walker, who in 2010 declared the Prop 8 mandate or marriage amendment unconstitutional. And that's where we stand. But there was a lot of debate as to what exactly happened in that district court opinion, whether it actually applied to all of California. And so now that we're back there, we have a mess, and it's gone to the California Supreme Court by the proponents again, and they've asked the California Supreme Court to sort it out.
Okay, so we have the governor of California and the attorney general declaring same-sex marriage legal in the state. One man and one woman marriage proponents have now petitioned the state's high court. What's behind this latest development?
Well, here's the legal issue. The proponents are actually saying you need more than a federal district court judge's opinion to render a California state law unconstitutional. There's this amendment, or there's a provision in the California Constitution that says unless there's an appellate court decision declaring a state law unconstitutional, then state officials, state agencies, including county clerks who issue marriage licenses, are required to comply with existing California law, which is Prop 8. So the argument is we don't have an appellate court decision yet. The other argument is that even if the federal court opinion somehow applies, it only applies to the 2 county clerks that were named in the lawsuit and were covered by the order, or the injunction, as it was called, to issue those same-sex marriage licenses. The other 56 counties were not represented in that courtroom. And so that's why the proponents are back at the Supreme Court saying, we need an order, a declaration, saying that these clerks should not be violating Prop 8.
This will be the 5th time that these justices have looked at same-sex marriage. What's been their track record?
Well, pros and cons. Back in 2004, the Supreme Court of California stopped the mayor of San Francisco from issuing same-sex marriage licenses. He took it upon himself to declare the law unconstitutional and ordered the city clerks to start issuing those licenses. The Supreme Court of California got involved and said, no, as an official of the state of California, you have to follow the law. That's good for where we're at right now. But in 2008, that same court also declared same-sex marriage to be the law in California, and which overturned another ballot initiative from 2000 called Prop 22. That decision's a bad one. Then fast forward to 2009, when Prop 8 was passed in 2008, it was challenged immediately on technical grounds. They said, now this amendment violates the standards for a ballot initiative. California Supreme Court says, no, it's fine. It passes all the tests, and that's a good decision. And then we had another trip to the California Supreme Court from the Ninth Circuit during the federal appeal, when the federal Ninth Circuit asked the state Supreme Court, under California law, do the proponents of Prop 8, the people who brought this to the ballot, do they have standing? Are they the legitimate parties to be bringing this appeal in the federal courts? State California Supreme Court said yes, they are. Otherwise, the integrity of the whole ballot initiative is undermined. They are the proper parties. So we've had some good successes. We've had some defeats at the California Supreme Court. And now, for the 5th time in 9 years, we're back there asking them to tell these state officials to comply with Prop 8 because it's still the law of California.
Now, you mentioned earlier this is a mess. There's a lot of things going on with this, but marriage isn't the only thing that's at stake in this decision.
Well, that's true. California's Constitution, as most state constitutions do, declares that all political power resides in the people. They delegate some of those powers to the legislature and to the governor and the attorney general. But still, that's delegated power. The final authority always rests with the people. And so ballot initiatives, when you go to the ballot and pass a law, you bypass the legislature, you bypass the governor, and that is pure democracy. That is, it reinforces the notion that the people really rule in California as in other states. By allowing what's happened so far to continue, that is, in effect, the governor and the attorney general have vetoed Prop 8 by refusing to defend it in the federal court appellate process, then the process gets undermined. The people lose respect for the democratic process, and in effect, we've lost power. The people have abdicated some power to the executives in the state. Already, since the Supreme Court decision, we've seen the Pennsylvania Attorney General also say that she is not going to defend Pennsylvania's marriage laws that have recently been challenged as to their constitutionality. So this thing is snowballing, and it's not good for democracy.
So what's next in this particular case?
Well, this is on a fast track. From what I can tell, the California Supreme Court has ordered briefing to be completed by August 1. I don't know if they plan to have a hearing on that, but we could have a decision soon.
Bruce, thank you so much for your insights on this. This really is a complicated issue, and we always appreciate getting clarity from you when you're on the show, so thanks.
Thanks, Kim.
And thank you for your communication with us. We love hearing what you think about the show and sharing your thoughts. You're always welcome to email us. That address is mail@citizenlink.com. That's mail@citizenlink.com. And we encourage you to pray for our elected officials and our nation. And remember, stand tall and be heard.